The treacherous waters of employee disabilities. We've gone from the Dangerous Wage Act to the treacherous waters of disability. This topic is an oldie but a goodie. I find that over the years, regardless of how experienced my clients are, HR professionals, CFOs, CEOs, managers who work with these issues, they always cause consternation because there are so many moving parts and overlapping issues. So today we're going to address these questions. When is an employee legally disabled? When is reasonable accommodation required? When is a requested accommodation not a reasonable accommodation? When is time off a reasonable accommodation? Is pay required for disability leave? And must benefits be provided during disability leave? So let's start with defining what is a disability. Actually, before I do that, let me talk to you about sort of conceptually how I look at this. I think of it as different pillars, and oftentimes it's easy to confuse the different pillars. But if you think of it as separate pillars, I think it's helpful. So the first is there a disability? The second is the employee entitled to reasonable accommodation? The third is, might that reasonable accommodation be time off? If that reasonable accommodation is time off, we then look at what other time off is the employee eligible for or entitled to, and might there be some overlap? And then we go to, is there pay available for that time off? Which is pay for time off is a separate issue from whether the time off is available to the employee, whether they're eligible for that time off. So, disability defined. An employee is disabled when they have a physical or mental impairment that substantially limits a major life activity. And you can believe that there's tons of law on what constitutes an impairment and what is a major life activity. But in Massachusetts, there is a liberal interpretation of the definition of a disability, or in Massachusetts law, it's actually called handicap. And under that liberal definition, you should always assume that someone who has an impairment that has a substantial medical condition is likely to be considered a disabled person, and caution should kick in, and you should start looking at this very carefully, potentially talking to us. Of course, discrimination against someone with a disability, or in Massachusetts a handicap, is prohibited by both state and federal law. And you cannot discriminate against somebody in Massachusetts because of their disability, or because they have a record of disability, a past record of disability, or because they might be perceived as or regarded as disabled. So the non-discrimination prohibitions go well beyond the existence of an actual present disability and expand the scope. So that's something to keep in mind. So let's start talking about that second pillar, reasonable accommodation. Reasonable accommodation is your obligation to provide when a qualified disabled person needs accommodation, needs some kind of modification or adjustment in their work schedule, the manner in which they do their work, etc., to perform the essential functions of their job. A qualified disabled person is someone who is able to perform the essential functions of their job with or without reasonable accommodation. Now, what constitutes a reasonable accommodation? An adjustment or a modification that enables the disabled person to perform the essential functions of their job. And these can be very diverse. They can be creative. Reasonable accommodations can span physically adapted facilities, workspaces, or equipment, something as simple as giving someone a stool for their feet, or some kind of a pad to rest their wrists on, raising or lowering their workstation. Modified work schedules. Sometimes that's pertinent depending on the person's disability and their particular individual medical needs. Modifying when or how an essential function is performed. Sometimes this can be trickier than it looks. For example, it may be that someone, for whatever reason, is unable to type, to use a keyboard, but that doesn't preclude them from say, editing, drafting, revising documents, or working in their computer, because of course there's technology available, such as voice recognition technology, that could enable them to produce, to do the role that they're required to do, to produce the product that they're required to produce, even if they can't type in that example. So modifying how they perform the essential function is an opportunity to think about exactly what is the essential function and how can we be creative to get there. Also, of course, light duty, reduced responsibilities, and possibly, in many instances, time off. Okay. When is an accommodation not reasonable? It's not reasonable when the accommodation would create an undue hardship for you as the employer. And looking at undue hardship is just as all these disability and accommodation issues are, a very case-specific analysis. Your business, your operations, your financial wherewithal, the size of your business, the type of business, might this create a financial hardship? Might this create an operational hardship? Might the accommodation that's being requested somehow threaten or compromise the health or safety of the employee requesting the accommodation or others? All of these are important questions to ask to determine whether there may be an undue hardship. And then, in order to accommodate the employee, to provide the reasonable accommodation that's required, and to also meet our business needs, our legitimate business needs, we're required to engage in an interactive dialogue with our employees to determine a reasonable accommodation. To be very clear, the accommodation that is requested by the employee is not necessarily the accommodation that you are required to provide. You do not have a requirement under the law to give the employee exactly the accommodation that they're requiring, but you do have an obligation under the law to engage in an interactive dialogue to figure out that balance. How can the employee be enabled to perform their essential functions, and how can you avoid any kind of undue hardship on your business? So the open and ongoing dialogue with the employee is required. You can also incorporate additional information that you get from the employee, that you get from the employee's healthcare provider. You can also consult with appropriate experts and consult appropriate resources. And depending on the circumstances, you can require an independent medical examination. Now, an example of a situation where the specific accommodation requested was not legally required is a case that came up in Massachusetts a number of years ago where there was a car mechanic. He worked in a body shop, and he had asthma. He had respiratory issues. And the accommodation that he and his physician requested was a certain kind of air filtration system for the shop, for the facility. And this case went all the way up through the courts, through the appellate system. And it turned out that the employer was suggesting an alternative. And that alternative was a filtration device that individual employee could wear on their face. So it was much more financially feasible. It didn't take such a big financial hit on the employer to provide this. It was something that the employee could do. The employee and his physician had turned this down out of hand, had said this is an inconvenience and it's not fair to burden the employee in this way to have to wear this device. The court said it is fair, and based on a balance of the employee's needs and the employer's needs, this is an appropriate, reasonable accommodation, and providing that individualized reasonable accommodation rather than installing a facility-wide filtration system was absolutely reasonable and appropriate, and the employer was in the right in that situation. Okay. Oftentimes, time off is an appropriate, reasonable accommodation. And I know that's sometimes hard to get our heads around, because how can you perform the essential functions of your job if you're not there? Good point. However, an accommodation constituting time off for a reasonable amount of time, an amount of time that you can absorb operationally and financially, is absolutely required to be provided. So time off as a reasonable accommodation, this is where we go to that next pillar and look at other kinds of time off that employee is eligible for and how they may interact with your reasonable accommodation time off. Time off as reasonable accommodation may overlap with or extend other leave entitlements, such as sick time. Some companies have an extended sick time policy. Some companies have a medical leave of absence policy. Of course, there's the family medical leave, and we heard from Emily today, there's the paid family medical leave. And there's also parental leave. So we have to think carefully about how the need for accommodation can dovetail with or overlap with, potentially be concurrent with these other kinds of leave that the employee may be entitled to. And all of these require, of course, time off with job restoration rights. The whole point is that you're giving this person a hiatus, and then you are required to restore them to their job or to the same or similar job. Okay, how much time off is reasonable? An accommodation is not reasonable when it creates an undue hardship, right? That's a general rule. Indefinite time off is not reasonable. If an employee brings you a note from a doctor that does not specify a return date at all, that's completely open-ended, that by law is presumed to be an unreasonable accommodation. You want to enter into an interactive dialogue with your employee and get a better sense of when they're going to be ready to return. Because it's not realistic, of course. It's burdensome to you as an employer to have this completely open-ended leave, this open-ended absence. On the other hand, if you get a doctor's note that has an anticipated return date and a reevaluation that will occur by the healthcare provider at that point, that is considered to be a finite period of time that is allowable as a reasonable accommodation. So there may not be a definite time, but if there's an anticipated return date and an opportunity for that healthcare provider to reevaluate the employee's situation at that point and their need for accommodation and extended leave at that point, that is something that you need to work with and to provide reasonable accommodation for. Now, I say here at least 12 weeks off is a good rule of thumb. For those of you who are smaller employers who are not governed by the FMLA, I've always said, look at the FMLA. The FMLA provides 12 weeks for a serious medical condition. That's a good rule of thumb. We, of course, heard earlier that in Massachusetts, starting in January of 2021, people with serious health conditions will be entitled to up to 26 weeks of leave. That's a half of a year. And so it may be that starting in 2021 or even starting sooner, we want to readjust our presumption as to what is the expectation of reasonableness with respect to time off as a reasonable accommodation. Obviously, as far as running your business, we need to think creatively about maybe temporarily replacing this person, about shifting their job responsibilities temporarily to other workers. There's no question it can be very difficult and challenging when you've got an employee out and you're providing time off as a reasonable accommodation. Maybe time off is not required, and use that interactive dialogue. Again, be flexible, be creative. Maybe working at home is a possibility. Maybe working at home part-time is a possibility. Maybe some kind of modified schedule or light duty is a possibility. As we talked about before, maybe modifying the way in which essential functions are performed is a possibility. Are there accommodations that will enable your employee to be present, to perform at least more of their job functions than would be possible if they take a complete leave of absence? It's worth exploring these questions, and you're entitled as an employer to have that give and take with your employee, to bring in their healthcare provider and ask them appropriate questions to determine what can be done. So now we're into that next pillar, which is you've got your time off. Time off as an accommodation does not require pay. But we go to the next question, which is how can this time off be paid? And obviously this is a pressing issue for your employees in most cases. They want to take the time off. They probably, in this case, they need the time off, and they're concerned about not being paid. So what is your responsibility? Your responsibility is consistent with all of your other policies with respect to paid time off. So the reasonable accommodation time off in and of itself does not require pay, but there are a lot of other opportunities that an employee has to be paid depending on which other policies are available to them. So some or all of the time may be paid using accrued and unused vacation time or sick time, or if you have a paid medical leave policy. A sick time bank. Sometimes employers have sick time banks where employees are able to contribute unused sick time to that bank so that other people in need can use it to be paid for their sick time. Do you have a short-term disability policy? Do you have a long-term disability policy? Was there a workplace injury? Is workers' comp coverage available? These are all the different pieces that need to be looked at to determine, based on the size of your company and your policies, how an employee can get paid, if they can get paid, for some or all of their reasonable accommodation time off. Are they entitled to benefits? While they're on this reasonable accommodation time off, they do not accrue any benefits. Just as if they're not working, they're not accruing their sick time, their vacation time, etc. However, they are entitled to health coverage throughout the leave, as long as it's handled in the same way as it would be if they were actively employed. So you should require your employees to continue to pay their portion of monthly premiums for health coverage. In the event that the leave is paid, obviously that would be deducted from their paycheck in the usual way. In the event that some or all of the leave is unpaid, you should require the employee to actually write you a check and pay for their portion of their monthly health care premiums. As far as other benefits, for the most part, you have to keep in mind, even though someone's on leave and they may not be present in your workplace, they're still an employee, and they're entitled to all the benefits and privileges of whatever policies you have in place. But I would defer to the specific plans, insurance plans, retirement plans, pension plans, etc., to determine exactly what is required during that leave time. Any questions on disability issues at this moment? Yes, Joe.
So, can you put a limit on can you set up a policy to limit how long the leave can be? So if someone is past their FMLA leave, they're past their long-term illness, they're on long-term disability. We currently don't have a policy in place saying that it's such and such a date. Can a policy like that be put in place?
No.
Okay.
You can't limit the amount of time that's going to be provided as time off for reasonable accommodation purposes on a broad scale, because each and every individual situation has to be dealt with based on the circumstances of that particular situation, that particular individual's needs, and the particular needs of your business related to that person's role.